Constitutional Law Professor Emerita, Lynne Rambo from Texas A&M. Thank you so much for joining us. Really appreciate it. As you know, the upcoming Senate impeachment trial is going to begin shortly of former President Trump. First of all, your thoughts about whether this is constitutional or not, because there have been so many different writings and views on this.
Yeah, for me, there's not really any question that it's constitutional for them to move forward. Not only is there nothing in the Constitution prohibiting it, there are two outcomes of a conviction. One is removal from office and the other is disqualification. And it seems pretty clear to me that in the event that disqualification is needed for a former officer, then they can be tried under the Constitution's processes. It's important to remember that when the Constitution was drafted, everyone was moving on horseback. So it's a little bit difficult to imagine how the framers thought that, darn, someone couldn't be disqualified from future office just because they couldn't reach the venue in time. So I think that that's just a technical argument that's being put up by the former president's lawyers.
What do you make of the fact that the Chief Justice has decided not to do this, and one of the Democratic senators is going to be presiding over the trial?
I would certainly have preferred it had Chief Justice Roberts been willing to do it, but I think that he's busy. And he can read the Constitution such that the president is not being tried for removal from office. And that's what the Constitution requires in terms of the Chief Justice presiding. So I don't think it means that much one way or the other. I would have preferred for the circumstance for the Chief Justice to be there, but I don't think it has enormous meaning.
Do you think that there is, in a sense, I've read some Republicans who believe that this opens the door for other past presidents to face this kind of scrutiny. What do you say to that?
Well, I have to hope that we don't ever again in the future face a situation where a president has challenged a legitimate election this way on falsehood, and people have responded in the way that they did. And I do think that the 2/3 requirement of conviction in the Senate is a very, very big impediment to charges being brought. I think the members of the House felt they had to bring this. I think they knew full well they might not get a conviction, but from a historical and precedent-setting perspective, they really needed to. So I think that notion that it's going to involve lots of impeachments in the future is kind of a red herring.
And what do you make of the fact, because the framers did set such a high bar for conviction, 67 senators, does that make cases when they're, in this case by the House, this is the second time for President Trump, because there is such a high bar and it doesn't look like they're going to come anywhere close to reaching that, should that make the House think twice about doing this?
That's a terrific question. I think it should certainly make them think twice, but at the end of the day, I think you have to do what's right from an ethical and public service standpoint. And the idea that we would have this pass unreacted to at all by our representatives is really a pretty horrible thought in the long view of history. So yes, they should think twice. They should always not waste time as our representatives. But on the other hand, the idea of letting it go completely unremarked by the body that supervises the presidential office seems really unthinkable to me.
Some people have mentioned, why not censor the former president? Is that strong enough in your view, or what's your thought about that?
I personally don't think so. I have a very difficult time imagining virtually any act more serious than the one that we witnessed on January 6th. And let me go back for a second to this idea that He's a former president, and so we can't try him. Let's assume a different situation for a moment. Let's assume that in his waning days, Donald Trump uh, just knowingly gave classified information to Putin, confessed, knowingly gave classified information to Putin, where no one could deny it whatsoever. Somehow, I don't think the Republicans would be arguing that he could not be convicted in a trial and disqualified from future office were that the case. And if that's not the case, then he should be able to be tried right now. And the offense was serious enough that it warrants going forward.
He is not going to be testifying at the trial. He's not going to show up. I guess we shouldn't be surprised by that. But what's your thought about that, and what argument do you think the Trump team can make?
In terms of his not testifying?
That and just as a defense.
Well, I mean, they're throwing up everything that they can, and that is their job as lawyers to do that, I suppose. In an ordinary trial, if someone chooses not to testify when it would make sense for them to testify, and it's not a criminal proceeding, a negative inference can be drawn by their failure to testify. So it makes it a little more difficult for them to argue on the merits. But again, we're running into this problem with the idea that the trial is kind of a foregone conclusion. We have a Republican Party that has a tremendous rift, and a group of people who are apparently very scared of a large portion of the electorate. And so they're going to do what they're going to do, irrespective of what the arguments are that are made.
So more of just this falls on political lines, which impeachments are political, from a large standpoint, I would imagine. What about the fact that couldn't the president face a criminal charge here of an incitement? And if he could, how strong a case would that be? I've read differing things on this, where a lot of lawyers say, even in a criminal setting, this wouldn't pass muster. The charge wouldn't really go anywhere.
If I'd say it wouldn't go anywhere, there are two things you have to look at. Assuming he were brought up on charges of inciting to riot under DC law or local law, in a criminal case, he would have the benefit of the First Amendment. So his remarks at the rally, because they are theoretically subject to two different interpretations, would be a real hurdle for a prosecutor to overcome. But the larger pattern of his behavior, in terms of whipping up the belief that the election was fraudulent when it was not, might be usable in a criminal setting in a larger prosecution for incitement. And the fact that he did nothing for hours and then gave a very, weak response to the rioters to try to get them to stop, all of that mixed into one might make for a criminal prosecution, but it would definitely have its hurdles.
And we have, since learned of information from these people who are being prosecuted by the United States Attorney's Office, offices around the country, that some of these folks plan to do this. Does that take away from the argument that the president's speech on January 6th incited, or does this come into play where you were referring to before about his comments after the election?
Well, that's a great question. I think it's going to depend on evidence that is yet to come out, and evidence that is just being gathered in terms of what was planned, what was being spoken about, what was communicated back and forth in various camps, including the president's. So I don't know that I think that their planning it particularly lets him off the hook to the extent that he joins in and further incites it. But that's an interesting perspective on it.
And let me ask you one other question, and I really appreciate your time, and that is just about if there is no conviction, and as we discussed, it doesn't seem likely. So if without the conviction, you can't prevent former President Trump from running for federal office again, right?
Right. What would pretty much be needed in order to disqualify him for running for future federal office, and it is federal office, by the way, would be that conviction in response to the impeachment. Otherwise, you run into real difficulties, and there's some Supreme Court case law on a representative out of New York with allowing people's choices to go forward. There's a balance that's got to be affected between who the people elect and legitimate disqualifications from office. So that is why this trial is not moot. Is because that issue of whether or not he should be disqualified from federal office is very much at hand.
Lynne Rambo, constitutional law professor emerita of Texas A&M. Thank you so much for joining us and all of your insight into this. Appreciate it.
Thank you, Jack. I appreciate it. Have a good day.